It's interesting because the original antitrust laws are very vague. They're short documents. They're not very precise about what the goals are. And so antitrust laws actually evolved over the last 100 years or so. And it evolved from a period before the 1970s when it was very contradictory that you're promoting both social or political outcomes, and you're often contrasting those with economic outcomes, thinking things like focus on consumers. And so it's evolved to the point we realized like that wasn't a very tractable regime. And now the entire field has kind of converged on the idea that really competition is about promoting consumer welfare. It's about like you want to promote competition, but then what is the goal of competition? The goal of competition is to deliver better goods and services for consumers. And so we've kind of ended up there because it's, like Commissioner Wilson said, it's administratable, it's a credible regime, and it offers certainty in a way that the previous regime didn't.
Commissioner Wilson mentioned, and as Alec mentioned now, that the antitrust laws have evolved to the point where we are obviously now at the consumer welfare standard, but that hasn't always been the case. And so there is a movement that's been around for a while, but certainly has gained steam with big tech for a movement back to a prior regime. We could call that the neo-Brandeisian, or just really just a throwback to the prior regime, to the consumer welfare standard. And so that's a competing paradigm right now, which is to work within the framework of the Sherman and the FTC and the Clayton Acts, and just to change the common law nature back to the way it was previously. There's nothing intellectually wrong with that. The laws can evolve, and so they want to sort of evolve it with a push back towards where it was previously. And an alternative regime, often in parallel but not mutually exclusive, is this idea of populist, or I should say regulatory regime for antitrust. I'll call it regulatory antitrust for lack of a better term. And the idea here is, whether as a substitute or complement, to really impose sort of structural presumptions, or even breaking up companies, or just imposing general interoperability requirements and various things that we think will help the market, which perhaps are well intended. But the goal is to use something outside of the statutory languages to help these markets become more competitive and efficient, or maybe even dropping those objectives and saying, look, we want other objectives as well, and we're going to be plain and transparent about that. And we think the consumer welfare is hindering that. And so really it is, to me, I guess we could throw in a libertarian argument that we don't need any antitrust at all, but that argument has largely lost favor. I don't think a lot of people have it, although I think, it's just as viable a regime as any of these other ones. But it's really down to these three regimes, right? So it's the consumer welfare standard today. It's throwing it back to the neo-Brandeisian world that we had yesterday. And it's really this regulatory antitrust that we're observing. And so to me, it's just an assessment of those three, which obviously is the subject of heavy debate and a lot of academic papers and speeches, but that's what we're down to right now.
No, there's a really great paper from DOJ in I think it's 1982 or something. It's very early in the sort of consumer welfare development, where they lay out some of the past Supreme Court decisions on antitrust. And some of the highlights for me were, they found it anti-competitive to merge because it would remove a corporation's headquarters from a small town to a big city. Or they found that it was part of a trend of lessening the number of single store groceries. And those were problematic mergers without a look at like how that would benefit or harm consumers. And they even allowed a case to go forward where the company's express purpose was they didn't want to compete. They wanted to stay out of this particular market, and so they didn't want to be forced to compete. So the antitrust laws, with all the different purposes, even if we step away from the sort of big picture policy arguments, there were, even in the economic sphere, there's a lot of economic interests that might want to use antitrust laws to benefit them, whether it be smaller businesses or bigger businesses or businesses in certain industries. And they have really competing interests. And if the courts have to try to continually pick between these, they're going to be sort of paralyzed. I mean, that was the analysis in this paper. And the consumer welfare standard helped focus that attention on something that pretty much, I think, still should be non-controversial, that markets, that the main beneficiaries of markets should be consumers who buy things from them. And that's why we should keep competition alive, because it benefits consumers. I don't think that the people who want to go back to these confusing, diametrically opposed approaches to antitrust want to point that out too much, because I think that would poll very well. Do you want markets to continue to make your life better as a consumer? Most people, I think, would agree with that. So So I think that consensus, I think, should be durable. It's been very workable. It doesn't mean the antitrust is perfect, but it does mean that it allows the agencies to focus on one dimension and to serve that dimension, and leave lots of other types of problems to other types of government solutions that maybe don't fit with the big hammer of breaking up companies or preventing transactions that the people involved think make business sense.